Board members present. To my left is Roy Akery, the acting fire chief. To his left is Scott Stokes, the director of public works, and Rosemary Rivera is the administrator, and she will be taking the official meeting minutes. First item for business is public hearing variance request V13020, reduction of west side building setback from 35 feet to 27 feet, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development. It's my understanding the applicant has requested that this item be tabled until Wednesday, October 23rd, 2013. Any comments from the staff?
Joey Stobbs, Planner 1 with Community Development. The applicant has just requested the item be tabled until the 23rd to have more time to work out the parking easement issue with Aldi.
Okay. All right. And this is a public hearing. If anyone would like to speak regarding this issue, I ask that you please step to the podium at this time. Seeing no one, I'd like to entertain a motion, please, and I guess we'll just do each one individually.
Make a motion we table variance request V13-020, reduction of west side building setback from 35 feet to 27 feet, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering Development.
Second motion.
It's been motioned and properly second that we table variance request V13020, reduction of west side building setback from 35 feet to 27 feet, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development. All in favor, please vote. All right, the motion passes unanimously. Public hearing variance request V13021, reduction of rear building setback from 100 feet to 85 feet, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development. I'd like to entertain a motion, please.
Make a motion that we table variance request V13-021 till 10/23/13, reduction of the building setback from 100 feet to 85 feet. It would be the rear building setback, 1.01 acres, land lot 847, 2591 Spring Road, Integrity and Engineering Development.
Second motion.
It's been motioned and properly second that we table variance request V13021. All in favor, please vote. Motion passes unanimously. Public hearing variance request V13022, parking reduction from 55 spaces to 41 spaces, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development. I'd like to entertain a motion, please, that we table this item.
Make a motion we table variance request V13-022 till 10/23/13. Variance request rear parking or parking reduction from 55 feet to 55 spaces to 41 spaces, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering Development.
Second motion.
It's been motioned and properly second that we table variance request V13022. All in favor, please vote. All right, motion passes unanimously. Public hearing variance request V13023, landscape strip reduction from 15 feet to 17 feet along Spring Road and 10 feet to 6 feet along Cumberland Boulevard, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development. I'd like to entertain a motion that we table this item until October 23rd.
Make a motion we table variance request V13-023 to 10/23/13. Landscape strip reduction from 15 feet to 7 feet along Spring Road and 10 feet to 6 feet along Cumberland Boulevard, 1.01 acres. Land lot 847, 2591 Spring Road, Integrity Engineering Development.
Second motion.
It's been motioned and properly second that we approve tabling variance request V13023. All in favor, please vote. All right, motion passes unanimously. Public hearing, variance request V13024, allow an additional directional sign at Spring Road and Cumberland Boulevard driveway, 1.01 acres, land lot 847, 2591 Spring Road, Integrity Engineering and Development, and I'd like to entertain a motion that we table this item until October 23rd.
Make a motion we table variance request V13-024. Variance request, allow for an additional directional sign at Spring Road and Cumberland Boulevard driveway, 1.01 acres. Land lot 847, 2591 Spring Road, Integrity Engineering Development for the meeting of 10/23/13.
Second.
It's been motioned and properly second that we table variance request V13024. All in favor, please vote. All right, motion passes unanimously. Next item is a public hearing, variance request V13039, allow reduction in side setback from 10 feet to 6 feet, 0.275 acres, land lot 374659 Burbank Drive, Shirley Gore. Is Ms. Gore? Please step to the podium. And for the record, can you state your name, please?
Shirley Gore.
Okay. All right, Ms. Gore, can you tell us about your variance request regarding the setback, please?
Okay, I don't know. Do you have copies of the plat up there and stuff? Okay.
Yeah.
The house is set, of course, up to, it's a cul-de-sac. And as you can see, it's like a triangle. On the on the right-hand rear area, there is a building my son built about 15 years ago. He uses it as a storage room. He has a pool table in there, his guitar stuff, just, things like that. There are two fences, and this is what you really can't see on this. This is the original fence right here, okay? And, so he and I measured the building. Then inside that, this is a chain fence that's going clear around it, okay? Then he built a 6 foot or whatever it is, what's allowed for a wooden fence inside there, to keep the dog in and just have a little more privacy and stuff. And he did that again 15 years ago, probably. Then this building is set about, and that wooden fence is approximately 4 to 5 feet from the chain fence. So there's 4 to 5 feet. Then you've got that building, and there would be two sides. There would be the one on the right-hand side that's kind of the diagonal, and the rear. And it sets about 4 to 5 feet. I measured it on one end, and it was like 9 foot 6 inches or something, and the other one was 10 foot 5 inches. It was like just a cattywampus, but it's really close to the 10-foot thing. It's been there for 15 years. It's very isolated back there. The lady that lives, her house on the right-hand side is is up close to where his is. In other words, you just look over and her house is there. All that's vacant land back there. Then back behind him, there are houses, but there's a strip of real heavy woods. In other words, you cannot see through there at absolutely all. We sent out the notices to all the neighbors. Talked to the one next door, which would be the one closest. She said she has no problem with it being there. Like I said, it's been there. She said she had almost forgot about it being there. And, it's just, it's so close to being to the 10 feet that, that's why I'm asking for the variance to be able to leave it there.
Okay. Any questions?
Yes, Ms. Gore.
Mm-hmm.
An accessory structure is something, that's on your property that's not connected to
Right.
the house. And I can see it looks like you have like an above ground pool. Is that right?
Right.
So that would be
Yeah, but see,
considered-
we didn't realize that.
Well, that's fine. But
we had a
I
pool
guess
in
where
my
I'm
other
going
house,
with this is is just for clarity and for the record.
Right, I understand that.
How many accessory structures
Well,
what do you have in your backyard?
the
pool would
others,
be one.
the pool would be one, and the other two would be hooked to the house. There's the screened-in porch hooked to the house, and then there's a little extension on the right-hand side.
Okay, but the one that's in the farthest back.
Far back, right.
Yeah.
That, like I say, it started out being, well, we let dog, if it gets real cold, he puts the dogs in there. He has the pool table in there, storage for pool items, and like I say, in other words, we don't mind getting the permit. I mean, he was in construction when he did it, but when you're building on your own property, you just don't think anything about it. He had just put the pool in. He needed a place to store stuff.
When you say he, you're talking about your
My
son?
son, right.
Okay.
Yeah.
So, and again, for the record, this structure that's in the farthest back right corner of your property, it's not connected to the house.
No, it's not connected to anything.
Does anybody live in that structure?
No. Like I said, they go out there and play in it and stuff like that.
Yeah, but nobody resides there. Nobody lives there. Okay.
So you don't live at this location?
No. Actually, my daughter owns it, but she lives out. I mean, she works out of town a lot, so she's not here. My son has lived there for like 25 years, and basically, I bought it for my kids.
Okay.
So, but you're the legal owner of the property.
No, my daughter is the actual legal, but she's not here. She's out of town right now. But I have her okay to do whatever you need to do. I mean, I owned it up until the first of the year, and then after my husband passed away, I decided to go on and just give it to him.
Okay.
Which is what I did.
Okay, so back to when I first started off, what would be considered an accessory structure. Again, for clarification for the record, we're trying to determine the number of structures that are not connected, because the overhead view that I'm looking at, looks at of course from the satellite view. If the pool is in your backyard, if you were standing at your back door,
Right.
the structure that we just talked about would be to the back far right corner.
Right, that's what
then you
I'm
have the
talking
pool straight ahead. Is there a structure to the left of the pool if you were standing at your back door?
There's, that's the screen-in porch, and it's hooked to the house. And then there's another little. It was like a hot tub room. Really, it was a screen-in porch, and he just put a lid on it.
Okay. So as far as accessory structures, we have the pool. Mm-hmm. You have the building that's farthest back. Mm-hmm. Is there another structure that's not connected to the house?
There's like a tent.
Okay.
You know what I'm talking about? Mm-hmm. And it can easily be taken down. It's just it protects stuff. I mean, he's in construction, and it just, it's there for. He's one of these. He loves to collect stuff.
Okay.
And of course, this house is only 900 square feet, and there's not a lot of room to put stuff in there. Like when my husband passed away, he wanted to keep a lot of his tools and stuff like that. And
okay. So would there be 2 or 3 structures in the backyard that are not connected?
Would you count that tent?
No.
Okay. There would be, I don't know what you mean by connected.
Well, connected to the house by a breezeway, a roof, a covered area.
That's what I said. Well, in other words, everything else is connected except the pool, and it's connected by the deck.
Well,
I
don't think that a deck.
But right. But it's out in the middle. Out in the middle, and then that one in there. The others are like that one is kind of like it's connected with a roof, and then the screen-in porch is connected by the roof.
Okay. It sounds like that there are 2.
Right. There's 2 accessory structures. Right.
Yeah. I think they're back up.
There we go. Okay. So, and I apologize. I'm just trying to get it clear.
That's all right.
So, there are 2 accessory structures: the pool and the one that's farthest away that is not connected by a breezeway or a roof.
They're connected by the roofs, but there are different type of roofs now. The screen-in porch, but now it's like I say, you know what a screen-in porch looks like.
Right. Well,
And
let's talk about the ones, again, I'm just trying to make it clear
Okay.
for the record. Let's talk
Okay.
about the ones that do not have a roof connection to the
Okay.
house.
It's the
It
pool.
would be the pool
And the one in the
and
far
the one
right-hand side.
far right-hand side. And those are the only two.
That's unless you're going to count that 10.
Okay.
Now, it's a freestanding with, tubing, and then it's like a tent-like.
Right. Well, I don't think that a tent qualifies as an accessory structure. We can hear from
Right.
city staff on that.
Any other questions? All right, well, at this time, we'll have the staff come up and make comments.
Okay.
Joey Stobbs.
There are two concurrent variances with this request, V13039 and V13040, reduction of the side setback from 10 feet to 6 feet, and to allow a second accessory structure. As the applicant has discussed, the pool house to the right rear of the property is, to the best of our knowledge, encroaching the side setback by 4 feet. I can only go by her pictures and her verbal declaration that it's about 6 feet from the fence, and the fence, to the best of my knowledge, is on the property line. So, therefore, it needs a reduction in the setback for 4 feet. Also, seeing as there is a in-ground or an above-ground pool there on the property, she would need a variance for the second accessory structure. Community development does not see a tent to be an accessory structure. And since the other structure to the front right is connected to the house, it's part of the primary structure. So therefore, it's not an accessory structure. That just leaves two accessory structures on the property. The applicant has notified her surrounding neighbors. Sign has been posted on the property. We received no comment from the surrounding neighbors. We recommended approval of the variance request without any conditions. That goes for V13039 and V13040. We just see these as a non-conforming building that's been there an undetermined amount of time, and we're just trying to clean these.
Yeah, I think her testimony was that it had been there for 15 years.
Right.
Yeah.
All right. Any questions?
Has anybody from community development staff been on the property to verify what we're seeing on this photography?
I've been to the property in the right-of-way. I haven't stepped foot on the property. That's generally not our authority to go on the property and to look over fences. So I can only go by Ms. Gore's word, and that's basically it. From the street, you can't tell, anything behind the fence. You can only see the house, the fence, and the tent is visible.
All right. Any other questions or comments? Scott, do you think we should have them take a measurement?
I think we should verify
Okay.
what's on the property just to ensure that we're giving this applicant the correct amount and the correct variances that are needed for to ensure that, they're not back up here. And again, I mean, we need to make sure that we're giving the property owner everything we can give them that necessary to make them be compliant. And I'm sure the property owner, I should hope, would allow staff to walk in the backyard just to verify this. And I don't want to have to do this again, and I'm sure the applicant doesn't want to have to do it again. And I don't know where these complaints came from, but I think we need to verify what's on the property.
Okay. Ms. Gore, would you be in agreement to letting the staff do that?
Yeah, I still don't think.
Step up to the podium so we can get you on record.
I still don't think y'all understand. I mean, the way that what you're looking at is the fence that was the chain fence. Then when my son built the wooden fence, that was 4 feet, and then the building is another 6 feet. So it is real. It's not quite 10 feet, but it's real close to 10 feet. But that's fine. Now I have dogs back there, so someone has to be there to control the dogs. Mm-hmm. So I have to make an appointment.
Okay.
Because they don't bite anybody there, but I wouldn't want anybody walking around that did not know them.
Right.
Ms. Gore, I just want to make sure that you understood the intent of this request of the board, because this variance request specifically is to allow the reduction of a side setback from 10 feet to 6 feet. And that 4 foot difference, from what I understand based off of staff testimony, is that it's kind of a best guess.
Right.
We haven't verified that. So in theory, you could really need 5 feet of variance instead of 4.
Right.
So if we were to approve it as it is, and then, there's other, claims that it still doesn't fall within, then we'd have to come back here and do all this over again. So it seems to us the simplest.
It's very close. I measured it on one side. My son and I, we were measuring on one side. And you have to go in. We'll have to get permission from the neighbor next door, because you're going to have to go in there. And that property is really full of needles and stuff. I'll tell you that right now. But you have to go over there to be able to see the 4 feet, and then his thing, you go to the 6 feet.
Okay. Staff is not going to be able to determine where the property line is. I mean, if we're discussing the setback issue, the only way to determine that is an as-built survey. So, I mean,
Never
Well,
had any complaints. It's just
Well, you supplied us with a survey, and the survey shows that fence, the chain link fence, on the line. I'm just asking, let's verify that there's a chain link fence there, that we pull a measurement off the chain link fence and make sure that she's where she thinks she is. I'm not saying we need to have we can ask her to have an as-built if you want, but I'm just more comfortable knowing what's in that backyard and that we're giving her the right stuff here.
You want to say something?
I do. Just for the record, I'm Jeffrey Tucker from the City Attorney's Office. Ms. Gore, when did you transfer title to the property to your daughter?
January or February, something.
Speak in here so that picks up.
January or February, sometime. I'm not sure. I have to go back and get the stuff.
And when was this variance request filed?
I don't know. Do you have a date?
You should have that.
Of last year?
No, this year.
Of this year. The City Attorney's Office takes the view that Ms. Gore lacks standing to apply for this variance. The code requires that any kind of quasi-judicial function, an action, can only be brought in the name of the real party in interest.
Okay.
And Ms. Gore, by virtue of having transferred the property, is not the real party in interest. Ms. Gore, I assume, is not a licensed attorney at law. And because she's not a licensed attorney, she can't prosecute this action in the name of the real party in interest. We could permit, if we'll table this for the time being, we can permit a simple substitution of the real party in interest, which is permitted by the code.
Okay.
Right. There's two names on that thing.
Okay. Well, would you step up and state that then? I don't have that in front of me.
Good morning. I'm senior planner with the Community Development Department, Rusty Martin. Miss Shirley is the applicant on the application, and the property owner, title owner, is her daughter, has signed the application as well. So by our account, she has given her the right to go ahead and act as a representation for this request.
Okay.
We could go ahead if that's what you want to do, but I think for record purposes, we do need a substitution of the name of the real party in interest as the applicant.
All right.
Okay.
Well, if that's the case, I mean, if we postpone this for another 2 weeks, that would give the staff an opportunity to take the measurements. So, I mean,
I never know when she's going to be in town.
And that's a question I had for the city attorney. Would this substitution would this just be a document, an agreement, or
I mean, on the records, it could simply be a strikeout of Ms. Gore's name and writing in the name of the property owner.
right?
And I mean, these hearings can go forward in the absence of the applicant. So I think that's fine.
okay.
I was just filling that thing out. She and I together.
I guess I don't understand where you're coming from.
Well, I haven't seen any of this. So.
Here's the title holder signature,
Right.
and this is the applicant. So she's given her, which is
Permission to
her, which is Shirley,
To stand in for her.
and here's Pamela, her daughter.
I guess the legal issue is that a variance from an ordinance affects an interest in property, and the interest in property can only be asserted by the property owner or by a licensed attorney at law. Where a board such as the License and Variance Board is assuming what's called a quasi-judicial function. So, for instance, if the title holder were, Ms. Gore could not go and file a lawsuit at Cobb Superior Court in the name, could not file it for, say, a quiet title action to land she is not the title holder on, and the title holder could not delegate to her the right to do that because only a licensed attorney at law can do it. So I think this is appropriate to be tabled until we can at least straighten this out on our papers.
Okay.
Well, I mean, in the legal sense, Ms. Gore, you don't own the property. If you have transferred it on the deed record to her, you have no interest in it, and in the same sense that just a random person off the street could not come in and apply for a variance on her behalf. But notwithstanding the fact that you were the owner for a long time, as of right now, you can't stand in her place and assert her right. That's the legal posture of this, and I'm afraid it's I wouldn't say opening the door, but it creates the possibility of other problems. Normally, only I can assert my own property rights, or an attorney can do it for me, but nobody else can step in, absent some special procedure of showing that I lack capacity or whatever, and do it for me.
Community development needs this policy on record, because typically when we have applicant, sometimes they're contractors or they're developers purchasing a piece of property that are the applicant for the rezoning, that have the signature of the property owner to move forward with that zoning. So if we're processing applications that are invalid, then we need to know what the policies are and what makes a legal application. I would just request that from the city's attorney's office, so we're clear as to what information we need.
That's fine. We'll clarify this. I certainly don't want to throw any wrench into the works. So.
Okay.
And I that's a valid consideration.
Okay, all right. Well, with that said, this is a public hearing, so if anyone else would like to speak regarding this issue, I ask that you step to the podium at this time. All right, well, seeing no one, I would like to entertain a motion that we table this item until October 23rd. If for some reason your daughter will not be in town,
There's no way.
okay,
Probably around the 1st of November.
all right. Well, why don't we table it, I guess, indefinitely until you can let community development know when she will be available to appear, or until we get the paperwork.
This building's there. She's not seeking to build.
All this trouble.
She's not seeking to build this building.
I mean,
so
poor dogs can live outside. I don't care. I mean, this winter they love to be inside there because it's warm.
Okay. I understand. The building is there. It's an existing structure. There's no rush to hear this. So when we can accommodate Miss Gore's daughter,
Okay.
and get her here, we'll do that.
When's the next hearing?
We have hearings the second and fourth Wednesday of every month.
Right, 10 a.m.
So there'll be
So
a lot of
usually it's a
time.
2-week period, except for the months we
So
have
the
a fifth
fourth
Wednesday.
will be Thanksgiving, though. What?
November 13th.
And Ms. Gore, for the record, it's not the intent of this board or anybody here to make this process difficult in any way, but it is our charge to make legal and lawful decisions. And I think that the city attorney's office has brought up a valid point.
Yes.
All we want to do is make sure that we're hearing and making decisions based off of legal and lawful applications. I don't know that there's going to be any issues with this, but other than the fact that we need the real property owner to legally make the application. And like we just said, it basically happens every 2 weeks. There's no real rush. I agree with city staff.
And I know she'll be in Indianapolis, I'm pretty sure, that weekend of the 13th.
Well, just at whatever point is convenient for her.
Then the next one will
No,
be
nobody's
Thanksgiving.
going to come over there and make you
Well,
try
you're
to
just out of
tear it
town
down or
somewhere.
anything like that. Well,
Out of town somewhere.
I can
That's what
appreciate
they're
that, but you also need to be able to appreciate the legal obligations that this board has.
That's why I kind of run her business, because she's gone so much.
Yes, ma'am.
I mean, it just, the building's been there, it's not bothering anybody. And I know, go further, because y'all don't
All
understand
right.
about the defense.
Having all of the evidence that Ms. Gore has given, the staff report, the testimony of staff recommendations, there shouldn't, as I said before, applications can be processed or can have an adjudication by the board without the applicant being present.
Okay.
And so there shouldn't be a necessity for Ms. Gore's daughter ever to come up
Of
here.
course, she wouldn't have to be here.
Yeah.
It just got to be rearranged on that piece of paper. Is that what you're telling me?
If that's even the determination, and we'll give an actual opinion on that.
Okay.
That's what I
I
know.
mean, I guess if that's the case, then what do we just discuss for the past 5 minutes? But yeah.
I
So
wasn't
okay.
discussing it, so.
I get, okay, as long as she doesn't have to be here.
Okay.
I'll be the one that'll be here, yeah.
All right. Well, as I mentioned, when you find out when she's available, you know the meeting dates. Just get in contact with the staff at Community Development, and we will.
It's the one right up you say it's the second week and the
Fourth.
Second and fourth Wednesday of every month.
4th in November. What is that date?
27th probably will not be one.
Yeah.
That's what I'm saying, because that's probably Thanksgiving then. God, that's going to put her,
And again,
going to be
as
December.
Ms. Gore, understand also the staff's recommendation to this board is for approval of your variance request. So we're not debating whether or not.
Have to be here. Isn't that what you just said?
Even if we substitute her in as the applicant doesn't have to be here.
She just needs to
We've already had
legally-
a public hearing on this.
Right now, you're the applicant, and she is signed saying that this is okay in essence. And I think that the stance the city attorney's office is taking is that the real property owner has to be the actual applicant. That doesn't mean that she has to physically be present.
Should have been on the top too then.
Yeah,
Is that correct?
Yeah, we're just going to check through this and make sure that we're not creating a problem for down the road. And going to Rusty's point, I don't want to create an additional problem for staff or the city by suggesting that we can't do it this way either. We'll check this out.
Okay.
Well, when will you let me know, or what's? I don't know exactly what to do.
She doesn't have to be here. We just have to go to the property and measure.
All right, go ahead.
All right.
I know.
Well,
busy.
let's table it to the 23rd, and
Yes.
it can
That's what
certainly
we're gonna
be
do.
That's what we're-
decided then.
Yeah.
That's what we're doing.
Okay.
We'll amend the application and do everything.
Yes. Thank you.
Okay.
I'd like to entertain a motion, please.
I got two.
Make a motion that we table variance request V13-039, that we table that variance request till 10/23/13 to straighten out the paperwork, to give city staff time to verify the condition versus what is on the plat. So I'll make that in the form of a motion on the side setback from 10 feet to 6 feet. 0.275 acres, land lot 659 Burbank Drive.
Second motion.
It's been motioned and properly second that we approve tabling variance request V13039 until October 23rd. All in favor, please vote. All right, motion passes unanimously. Next item is a public hearing. We're also going to table this item, variance request V13040, allow second accessory structure, 0.275 acres, land lot 374, 659 Burbank Drive. Shirley Gore is the applicant.
Make a motion that we table variance request V13-040, allow second accessory structure, 0.275 acres, land lot 374, 659 Burbank Drive, to clarify or to correct the application and to allow staff to verify the condition in the rear yard versus the site plan.
Second.
It's been motioned and properly second that we table variance request V13040. All in favor, please vote. All right, motion passes unanimously. Thank you, Ms. Gore. Okay. Next item is a public hearing, variance request V13041, allow reduction of impervious stream buffer from 25 feet to 21 feet, 0.42 acres, land lot 456, 3303 Woodcrest Court, Bradley Hall. Is Mr. Hall here? Please step to the podium. And for the record, can you state your name, please?
Bradley Hall.
All right, and can you tell us about your variance request?
There's a 25-foot there's a stream at the back of the properties, two properties next to each other. There's a stream, there's a 25-foot state stream buffer, and another additional 25-foot impervious or clearing, grading, which, we're not doing anything with that. And then there's an additional 25-foot, which is from 50 to 75 to make it a total of 75 foot of impervious, where you can clear, you can grade, but you're not allowed to put any permanent structures, which a deck is considered through City of Smyrna code as a permanent structure. And I'm asking for the impervious 25 foot to in order to get the house in a marketable condition for the community and for the area. We're asking for each lot has its own square footage on the site plans that we submitted, but the square footage that we are going to take up in impervious, we're making it up on the same lot in a different area. So basically, substitution of impervious. It's not really losing the impervious. We're just making up for it on a different location on that lot.
So, Mr. Hall, would it be accurate to say that the outside impervious buffer, which is 25 feet, you're requesting to reduce that to 21 feet from 25? And is it true that that's because of a deck? So there'll be a deck that would impede in the impervious buffer by 4 feet.
Well,
Is that
just
correct?
considering that the plans and the floor plans of the house, the deck is included.
Right.
So whether it's a deck or house or whatever it is, it's impervious is the issue. It doesn't matter. The issue isn't whether it's a deck or whether it's a part of the house. We're impeding on the impervious, measured from the center line of the creek, and we're making up for it on a different location on the same property.
All right. Any other questions?
Are you the owner?
My business is?
Are you the applicant?
Yes.
Okay.
All right. Any other questions? No more? All right. Well, at this time, we'll have the staff step up and make comments. Mr. Stobbs, please.
Okay, there, 3303 Woodcrest Court. The applicant is requesting a reduction in the impervious surface buffer from 25 feet to 21 feet. And really, as the applicant has stated, it is only the corner of the deck that encroaches into this impervious buffer. That is a total of 14.5 square feet that encroaches the buffer. It is not the whole, the whole house or the whole deck is not encroaching 4 feet into the buffer. So there's only the corner section. We've reviewed the request. We've posted signage. There has been some calls to our department about this request. Most of the neighbors that have called seem to understand the request. I don't really know if they're in support or not, but we've recommended approval of the variance request with 2 conditions. The applicant record a plat of the subject property with the proposed offset area to remain undisturbed. And again, to clarify, the 14.5 square feet that is encroaching the impervious buffer will be offset in another area, and that will be recorded on the plat. And 2, approval of the requested variance shall be conditioned upon the development of the property in substantial compliance with the site plan submitted with the variance application. Any questions?
Has the city engineer looked at this?
He has, and he has no issues with the request.
No issues?
No.
Were these already legal lots of record?
Yes. This is part of the Reed Place subdivision that was platted in 1996, I believe. And these 2 properties have remained undeveloped. Probably there's a severe slope on these 2 properties, and the buffers make the lots unbuildable without a variance.
Any other questions?
And I should also mention the impervious buffer is a city buffer. I think that stream buffer ordinance was adopted in 2005, which was well after these lots were platted. So the original subdivision plat would not have contemplated these buffers. It would have only contemplated the state 25-foot buffer.
Okay. And there was proper signage posted in the...
Yes.
Okay. All right, well, this is a public hearing. If anyone would like to speak regarding this issue, I ask that you please step to the podium at this time. And
I'm going to administer an oath.
he's going to swear you in.
Going to speak on this. So,
Is there anybody else regarding this issue?
if you'll, I'll only administer one oath to you.
If anybody feels that they want to speak on this issue, come up and get sworn in now.
You even
Sure. If both of you would just raise your right hand. So, do you solemnly swear the testimony you give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. If you'll speak clearly into the microphone so that
Yes.
we can get a nice record here.
My name is William Pamplin. I'm a resident of this neighborhood. I wish to oppose approval of variance number V13-041 and further request that the variance be presented to the Smyrna City Council for review.
okay.
Okay, thank you, sir.
Hello, my name is Kathy Carter, and I am also a resident of the Reed Place subdivision. I am also on the HOA board, and I just wanted to let you know that we have had some conversations with Mr. Hall via our attorney, and we have received his plans for both properties. And we have a couple of issues that we have outlined here for him. And if I can give this
Yes.
to you for your review.
You can give it to Rosemary. We'll put it in the record.
So we have not gone through all of the, we have received his request and the plans for the first lot. And we had some concerns about grading and clearing the initial lots. There are 2 lots involved. So the variance is for both lots, as I understand. So he would then have the opportunity to grade both lots at one time, which is of concern to the HOA board. And so that's one of the issues that we have here. And we've outlined several different issues in this communication. So
You said Mr. Hall does have a copy of that?
yes.
Okay.
I got it last night at 6 o'clock.
Okay.
All right, clarified, there are 2 variances.
Yes.
So
Yeah, there.
the
When
board
you
has
mentioned
the ability to approve one or deny the other.
that there are 2 separate lots and 2 separate variance requests, one per lot.
Yes.
Yeah. Okay, so would you say that you approve of or oppose?
I oppose.
Okay.
Okay. I'd like to entertain a motion that we go into executive session.
So move.
Second.
It's been motioned and properly second that we go into executive session at 10:48 a.m. All in favor, please vote. All right, motion passes unanimously.
Motion to reconvene.
Second motion.
It's been motioned and properly second that we reconvene from executive session at 10:52 a.m. All in favor, please vote. All right, motion passes unanimously. In regards to variance request V13040, I'm sorry, 041, reduction of impervious stream buffer from 25 feet to 21 feet. Mr. Hall, you being the applicant, typically when we have an opposition to a variance request, we do push it up to the mayor and council for consideration. So that's what I will be recommending that we do in this case today. So with that said, I'd like to entertain a motion, please.
You push it up to what?
To the mayor and council.
So
Okay.
basically, what's going to happen is I'm going to make a motion to deny, and we're going to vote on those motions. Assuming that the motion to deny passed, you would have an appeal right. We would encourage you to continue the process, the same process as you're doing right now, just one step further to the mayor and council at a city council meeting.
Okay, can I get clarification for the purposes from the people that oppose? Why they oppose?
Well, I think that would probably be between you and the people who oppose.
You don't need a reason for opposition?
Yeah, anytime there's
Okay.
an opposition,
Right.
it goes up to the mayor and council, and you have 10 business days from today to notify the city clerk's office
Okay.
to get on the next city council agenda, and the mayor and council meet on the first and third Monday of every month at 7 p.m.
Perfect. Thank you.
Yeah. Yes, Rusty.
Just for staff's purposes, so we're not starting from scratch at the next meeting, I would recommend that we ask the people who spoke in opposition to the request to state what their opposition is, so we have an opportunity to address some of those issues prior to going to the meeting, and it also helps facilitate the meeting at the mayor and council level.
Okay, all right.
That, as a practical matter, that's a good idea.
Okay.
If the people who spoke don't want to say anything further, they're certainly not required to.
Okay, all right. The two individuals that spoke, are you willing to state your reasons why
Yeah.
you are in opposition?
Yes, and actually they're outlined in this letter, and
Okay.
I'm happy to give this to.
Yeah, and we do have a
Another
copy,
copy.
and I understand that Mr. Hall.
Has a copy. So
Yeah, and he
I'm
said
not-
he just got it last night, so, I mean, for the record, if we
I can give you a copy here if you'd like to.
Yeah, I've got the copy, but none of this has anything to do with the variance. It has to do with the brick color, the
No, it does
grading,
have
the grading of the
grading.
lots,
And the clearing of the lots.
and that's all
With the-
doesn't pertain to the variance.
Okay.
And the page to the HOA, which I am going to abide by, but it doesn't pertain to the variance.
All right. Well, can you speak to the variance in opposition?
I feel like it does
Okay.
speak to the variance.
Okay.
With what has to be done for the grading of the property.
All right.
And the clearing. It's going outside the buffer. It's not something that we feel is going to be good for our community.
Okay.
Well, also, you understand that they can grade on an impervious stream buffer without a variance. The variance is
Right, for the
because of the
building.
encroachment of the permanent structure.
Understood.
Okay.
Understood.
And sir, did you have anything to add to the record for your opposition?
Again, for the record, I'm William Pamplin, and you've asked me to comment further on my reasons for opposition. These two lots are considered, shall we say, topographically challenged. Several home builders, including the original neighborhood developer Trayton Homes, one of Atlanta's major home builders, have declined to build on either lot because of these topographical challenges. Now, I'm not sure to how this addresses the variance, but I will continue by saying that from the front of the lots on Woodcrest Court, both lots, to the boundary creek at the rear of the property, there exists a drop in elevation of almost 50 feet. Portions of both lots lie within the floodplain of the permanent boundary creek, within the floodplain. If we have another deluge like we did in Powder Springs several years ago, there's going to be a lot of water back there, sir and ma'am. Anything else?
Thank you.
Thank you.
Based off of public opposition, make a motion to deny variance request V13-041 to allow the reduction of impervious stream buffer from 25 feet to 21 at a .42 acre lot, land lot 456 at 3303 Woodcrest Court for Mr. Bradley Hall.
Second.
It's been motioned and properly second that we deny variance request V13041, allow reduction of impervious stream buffer from 25 feet to 21 feet, 0.42 acres, land lot 456 3303 Woodcrest Court. Bradley Hall is the applicant. All in favor, please vote. All right, motion passes unanimously. And Mr. Hall, just a reminder, you have 10 days, business days, to contact the city clerk's office to be placed on the next city council agenda or an upcoming agenda date. Next item is a public hearing, variance request V13042, allow elimination of impervious stream buffer, 0.51 acres, land lot 456, 3305 Woodcrest Court. Bradley Hall is the applicant. Is there any additional comments, Mr. Hall, you'd like to make about this item? Okay. All right. The staff, do you have any comments?
V13042, it's a similar variance. The applicant is requesting to allow the elimination of the 25-foot impervious surface buffer. This is due to 1,297 square feet of the home that will encroach into the impervious buffer. We have proposed a similar we have proposed that the applicant offset that 1,297 square feet and demark a 1,297 square feet area that will remain undisturbed. Again, this is a lot that was established in 1996. The stream buffer ordinance was adopted in 2005. In 96, only the state 25-foot buffer, undisturbed buffer, would have applied. In regards to any grading concerns, we have a soil erosion inspector on staff that inspects every development, regularly fines developers that violate the erosion control ordinance. So we have a very watchful eye on development, and in regards to grading and erosion, that is a regular concern that we watch with any development, much less a delicate site such as this. So the applicant has notified the residents and the HOA. Signage has been posted. We recommended approval with the same conditions. The applicant record a plat of the subject property with proposed offset area to remain undisturbed. And 2, Approval of the requested variance shall be conditioned upon the development of the property in substantial compliance with the site plan submitted with the variance application. And also, I think the board has the ability to just forward this to mayor and council rather than deny, unless the board just wants to deny it. But that's up to you. Thank you.
Thank you. Any questions for the staff? All right. This is a public hearing as well. If anyone would like to speak regarding this issue, I ask that you please step to the podium at this time. And for the record, can you please state your name?
My name is William Pamplin. Do I need to be sworn in again?
No.
No.
It looks like we have a new person, so she would have to be sworn in.
She will. I'm sorry.
Okay.
Sure. I didn't realize there was somebody else. Please raise your right hand. Do you solemnly swear the testimony you give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you'll have a seat, we'll let Mr. Pamplin speak again first.
Thank you.
I guess also for the record, what's your address, sir?
My address, ladies and gentlemen, is 3301 Woodcrest Court. These two properties adjoin my home. And my statement is identical to my last statement. I wish to oppose approval of variance request V13-042 and hereby request that the variance be presented to Smyrna City Council for review for the same reasons that I stated before.
Okay.
Do
All
I
right.
need to repeat them?
You can.
Uh,
Go ahead. For the record.
For the record, several home builders, including the original neighborhood developer Trayton Homes, have declined to build on either lot because of significant topographical challenges. To wit, from the front of the lots on Woodcrest Court to the Boundary Creek at the rear of the lots, there exists a drop in elevation of almost 50 feet. Portions of both lots lie within the floodplain of the permanent Boundary Creek at the rear of the property.
Thank you.
Thank you very much.
Next person. And for the record, can you please state your name?
Sure. My name's Jennifer Cook. I live at 3306 Woodcrest Court,
Okay.
next to this property. My concern with this variance is that we've not seen any plans, actually, unlike the previous lot. I think he does have plans as far as where the house is going to be. With this lot, I don't think any, to my knowledge, there have been no plans as far as where the actual house is going to be. So hearing 1,200 square feet, worth of house is going to be in this buffer, I feel like maybe we just need more information before we would approve the variance. So I'm opposed to the variance at this time.
Okay.
Thank you.
All right. With that said, I would like to entertain a motion, please.
Make a motion that we deny variance request V13-042, elimination of impervious stream total or all elimination of impervious stream buffer at 0.51 acres, land lot 5, 456, 3305 Woodcrest Court. Make that form of motion.
Second.
It's been motioned and properly second that we deny variance request V13042, allow elimination of impervious stream buffer 0.15 acres, land lot 456, 3305 Woodcrest Court. Bradley Hall is the applicant. All in favor, please vote. Motion passes unanimously. And again, Mr. Hall, you have 10 days, business days, to notify the city clerk's office in regards to this item being on an upcoming city council agenda for their hearing. All right. Thank you very much. Next item is appeal the denial of the application for alcohol server permit. Ann Newton. Is Ms. Newton present? Okay.
Hello, my name is Ann Newton.
Okay. All right. And actually, I'm going to turn it over to our Assistant City Attorney, Jeffrey Tucker.
if you'll have a seat for just a minute, we need to get something else on the record first. So
Okay.
let me. Let's if you'll step back up here, let's swear both of these because we're going to have some facts here. So if you'll both raise your right hand, do you solemnly swear the testimony you give in this matter should be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. We know the board knows who you are, but please state clearly into the microphone for the record your name, please.
Marla Gerber.
And are you employed with the city, Ms. Gerber?
Yes, I am.
And what do you do who do you work for the city, and what do you do?
I work for the police department and the permits office.
And so, in that capacity, when there's an application for alcohol server permit, that comes in, what do you do?
I process the application and run a background check on the applicant
and
to see that they meet the requirements for the permit.
And then if you find something that would prohibit them under the municipal code from receiving the permit, what do you do?
We notify the applicant and tell them that they have the right to appeal our decision.
Right, and the notice that you send them specifically says why they're not eligible under the code.
Correct.
Is that correct?
Correct.
So this specific matter has to do with Ann Elizabeth Newton. Did you run the criminal background check in connection with this application in the regular course of business?
It was run, but not by me.
Okay, but do you recognize
Yes.
this criminal history record?
Yes,
And
I
this
do.
is a record that's kept in the regular course of business there by the Smyrna Police? Or it's run in the regular course of business by Smyrna Police? And does this appear to be what the board has in front of them? Does this appear to be an accurate representation of the record as it was run? And did your review of this record disclose anything in the record that would prohibit this applicant under the code from receiving an alcohol server permit?
Yes, it did.
And what was that?
Felony conviction within the past 5 years.
And what was the date of the felony conviction?
The conviction date was
I will show the witness
2010.
I will show the witness something to refresh her recollection.
7/1 of 2010.
That means July 1st, 2010, and that's within the past 5 years.
Correct.
Yeah. Okay. And so I don't have any further question for Ms. Gerber. The board can ask her questions, or the applicant, I think, can ask her questions as well. Do you have any question for her? No. Okay. All right. Thank you, Ms. Gerber.
Okay.
All right. And so if we can have Ms. Newton come up here, please. If you'll let me show you a copy of this record. Have you ever state your name for the record, please?
Ann Newton.
And have you ever been known by any other name?
Ann Muther.
Okay. And so if I show you these names in this record, these are all the same person, right? These
Yes,
are all
sir.
you.
Yes, they are.
All right. And without belaboring this point, do you have a felony conviction here in Georgia within the last 5 years?
Yes, sir, I do.
Okay. I don't have any further questions for Ms. Newton. We'll take questions from the board.
Ms. Newton, just for the record, you don't deny the accuracy of the criminal background history.
No, sir, I do
and
not.
you, just like you just said, you admit to having a felony conviction
Yes,
within
sir,
the
I
last
do.
5 years.
Yes.
Okay, thank you.
Are you currently working?
Yes, ma'am, I am.
Okay, where?
I work at Timbers. I work there as a cook.
Okay, all right. And, I mean, can you just explain to the board why we should...
What I'm asking for is that, I'm a cook and a manager, but I can't really, I'm not being utilized to my fullest capacity because I can't serve alcohol. I have made major changes in the last, 4 years. I'm a student full-time. I'm going for an associate's degree in healthcare management. I'm just trying to better myself, but as far as my job is concerned, where I'm at, I can't. I mean, I cook, but at times I'm needed to be managing the front of the house, and I can't do that effectively if I can't touch alcohol at all, and I don't. So it does put a hindrance on my job, and it has, at times, I mean, cooking there is really, really hard on me, and I don't know how much longer I'm going to be able to do it in order to, get through school. I don't want to lose my job altogether because, I can't serve alcohol. So I'm just asking, that, to take into consideration, the changes that I have made, and that's why I'm here today.
Thank you.
Where are you in school?
I am 2 months into my program. I go to school. It's an online course, course.
What's the name of the school?
Ultimate Medical Academy.
Okay.
And I have straight A's. I'm considered a full-time student. I've been off of parole and probation for 2.5 years now. I continue to make the choice of my own to stay on the right path. There's nothing that will steer me from this. I'm really excited about school and about what the future holds for me. I've just done nothing but make the right choices and decisions in the last 4 years. So, and I will continue to do so.
But do you understand that our city code prohibits anybody with a felony within the last 5 years to receive a server permit?
Yes, ma'am, I do understand that, yes.
Okay, all right.
Yes.
How long have you been at Timbers?
I've been there for 1.5 years.
And the need to serve alcohol just now arose?
Well, no, I did apply back in the beginning of March, but I wasn't told I only had 10 days to submit the appeal, and so I tried to contact the clerk court, and I didn't get a call back, and then that window of opportunity kind of slipped away, so I had to wait another 6 months to reapply. I also really just I just didn't think that enough time had gone by to come in and ask for a permit. I felt that 3 years since the conviction, would be sufficient to just prove myself that, and to the city that I've made changes and I'm continued to stand by those changes. So I just felt that I just needed a little bit more time. I didn't want to just come right away. I had something to prove to myself and and to you guys that I was, that this is where I'm at and this is where I'm going to stay.
So this is basically a step forward in your career at Timbers, or is this just something that's necessary for you to remain employed?
Well, I've been working for my boss at Timbers on and off for the last 17, 18 years. I worked for him at Bones when Bones was on South Cobb Drive. And so, Terry asked me to come and help him out, but I told him I couldn't serve alcohol, but so he just wanted me. He was really sick, and his partner was sick with cancer, and he passed away. So I came in, and I helped him out, and then when he got better, it was like I really, didn't want to be let go. So he, I wasn't serving alcohol, but now he was there physically to work and do the things that I was in there doing that he wasn't there to do. So instead of losing a job, he put me to cook, but it's just I could be better utilized as far as what I do by being able to help out serve alcohol. I'm not asking to serve, to become a bartender and be full time. I'm just asking to be better utilized at my job, until I can, finish school and look for a better job.
Thanks.
Any other questions?
What years did you work for him at Bones?
I worked for him at Bones from 1997 when he first opened, for the first 8 years that he was there.
Did you have an alcohol serving
Yes,
permit?
I sure did.
From us at that time?
Yes, ma'am, I did.
Okay.
I sure did.
All right.
Okay, go ahead.
Okay. All right. Well, Ms. Newton, I'm going to have to recommend denial because, we have to abide by our city codes.
Yes, ma'am.
And, because you have had a felony drug conviction within the last 5 years, that would, make you ineligible for a server permit. So with that said, I'm going to recommend that we entertain a motion to deny the application for Ms. Ann Newton.
Will I be able to appeal that
Yes, you
to
will.
the mayor,
And-
ma'am?
Yeah, and I was going to mention that, but yes, you will have 10 business days from today to notify the city clerk's office, Terry Graham, who you've already spoke to.
Yes, ma'am.
And she can work with you to get on an upcoming agenda for the mayor and city council.
Yes,
and the council meets on the first and third Monday at 7:30 p.m.
Okay.
here in this room.
Yes, ma'am. Thank you. All right.
I'd like to make a motion to deny 2013-353, which is the appeal for the denial of the application for alcohol server permit for Miss Annie Newton.
Second.
It's been motioned and properly second that we deny the application for a server permit for Mrs. Ann Newton. All in favor, please vote. All right, motion passes unanimously. So, Ms. Newton, if you do want to get on the agenda, please contact the office within 10 business days. Okay, thank you for coming.
Kevin, can I, is that, you'll get a written
All right, and next item on the agenda is approval of the meeting minutes for the License and Variance Board meeting of September the 11th, 2013. Oh, yes, sorry, thank you. I didn't see him here. Okay.
Yeah.
All right, next item is actually an appeal of the denial of the application for alcohol server permit, DeWitt Mamo, and
Mr. Mamo does not appear to be here, and as far as I know, has not requested this to be considered at any later time, so we can consider it.
speaking to the mic, please.
Absent being corrected, Mr. Mamo does not appear to be here, and to the best of my knowledge has not either through my office or the clerk's office or Ms. Rivera's office or anywhere else appealed for or asked the board to postpone this decision to any later time so it can be considered right now.
All right. And Ms. Rivera, as far as you know, he was notified that he needed to be here based upon his submission for us to hear this denial for his permit.
Yes.
Okay, thank you. So do we just...
You want to give us a background on it so we can hear it?
Well, the applicant appears from his own written submissions to be an individual who has applied for alcohol server permit. I believe, according to his written statement that he's turned in, that was processed by the city clerk, to be working at one of the convenience stores, and in order to sell beer there, you have to have the server permit. So if I could get Marla to step back up, we'll just enter this the criminal background information into the record.
Okay.
Ms. Gerber, you've already been sworn today. Did you run, or did someone at the police run a criminal background check for DeWitt Mamo?
Yes.
All right, and based on, let me, if I can flip through some of this, did the diversion agreement come to you, or was this something that he sent?
No, he brought it in with him.
Okay, so this is something that's in the police record. So
Right.
so all of this is an accurate police record, and this the record shows a charge that was looks like June of last year, a felony charge for commercial gambling. Is that correct?
Correct.
And then Mr. Mamo appears to have entered into the diversion program, under which he wouldn't, the prosecution wouldn't continue as long as he successfully completed the diversion program, which is still ongoing, apparently from the record, and in which, if he does not successfully complete it, and it's not completed yet, then he will be charged for the pending felony. Is that correct?
Correct.
Okay. All right. So, if the board has any questions for Ms. Gerber, we can take questions as to the record.
I don't have any questions for her.
Okay.
Any questions?
And in the absence of Mr. Mamo to ask any questions for him, he submitted this record himself.
Okay.
The provisions of the municipal code say if there are pending felony charges, then there has to be a postponement of final adjudication of the appeal. Just on the face of the diversion documents that he submitted, his pretrial diversion program is not completed. Therefore, he still has a pending commercial gambling felony charge. Okay.
And if I'm reading this paperwork correctly, the program is 6 months?
It appears from what the court issued to him, and he initialed and signed this, and it looks like his lawyer did as well. It's 6 months, and this was just entered, September the 17th of this year. So it won't run out until March of next year.
Okay.
Assuming he successfully completes it, but until that time, he'll have a pending felony.
Okay. So with that said, I guess we can continue this in his absence.
Yes, we can continue. This is his.
Okay.
He has appealed the denial.
Okay.
And
all
so
right.
he's failed to appear to prosecute this, but yeah, it can be considered in his absence.
All right.
Assuming, I think Ms. Rivera said he was properly notified. All right.
Okay.
Yes, he just filed it for this application on the 1st of October, so it's only been 8 days.
Okay.
I don't know how he could forget.
All right. Well, with that said, and with the evidence that has been, or documents rather, that has been presented to us, I would like to entertain a motion that we postpone this appeal pending final adjudication of charges. Is that?
I think that's proper under the code. It says a final decision shall be postponed pending adjudication of a pending felony.
Okay.
In reference to 2013-354, make a motion to postpone the final action of this appeal pending final adjudication of charges, or the appeal of the denial of the application for alcohol service permit by Mr. DeWitt Mamo.
Second motion.
It's been motioned and properly second that we deny appeal of the application for alcohol server. Postpone, pardon me. application of server permit for DeWitt Mamo, pending final adjudication of charges. All in favor, please vote. Okay. Just raise your hands then. Okay. All right, motion passes unanimously. Last item on the agenda is approval of the meeting minutes for the License and Variance Board meeting of September the 11th, 2013. I'd like to entertain a motion, please.
Motion to approve the minutes for LMV board meeting of 9/11 of 13.
Second.
It's been motioned and properly second that we approve the meeting minutes for License and Variance Board meeting of September 11th, 2013. All in favor? Please vote. All right, motion passes unanimously. I'd like to declare this meeting adjourned at 11:28 a.m. Thank you. No.